Yeah. Good evening, everyone. I'm CA Mayuri Daga, moderator of this webinar. And we are delighted to welcome you all in this webinar being organized by the Committee of Commercial Laws, Economic Advisory and NPO Cooperatives of ICI. It's my pleasure to be moderator in webinar on professional opportunities for chartered accountants in IPR on 21st November from 7 p.m. to from 5 p.m. to 7 p.m., which is being organized by the CCLEA and MPO Committee of ICI. In a short while, we will start this webinar, and I would like to apprise you about the committee, CCLEA and NPO. This committee is focused to encourage chartered accountants to shape strategy and policy that unlocks economic and financial and social value while combining analytical foresight with commercial acumen. And one of the core areas of this committee is to serve multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formation, to develop and publish technical guidelines, background materials, etc., and to create awareness for professional opportunities for chartered accountants in commercial laws, economic advisory, and NPO cooperatives. Our eminent speaker will talk on professional opportunities for chartered accountants in IPR in this webinar, and we hope that it shall be useful to all the members. Now, I would like to introduce our speaker, Advocate Neha Gupta. Ms. Neha Gupta is a practicing advocate and a qualified company secretary and a commerce graduate. During her more than 13 years of professional career, she worked in top-notch consulting firms in India and currently acting as a proprietor of Messrs. NRG and Associates, advocates and legal consultants. Initially, she had been involved in vast range of professional assignments, including secretarial services, FEMA compliances, and company law matters, and having deep interest in the intellectual property rights matter and issues. She pursued her career in this IPR since 2010 onwards. Her expertise lies in all aspects of intellectual property laws, especially in trademark, copyright, design, and patent. She extensively and independently handles matters relating to filing, creation, consultancy, prosecution, litigation, mediation, rates, protection, settlement, and enforcement of above intellectual properties in various courts and forums across all over India. I welcome you, ma'am, on behalf of the committee, and we can proceed with the subject.
Thank you so much, ma'am. Good evening, everyone. And thank you, team ICI. Am I audible?
Yes, ma'am, you're audible.
Okay, thank you so much. Thank you, team ICI, for inviting me here for this session. The present session is an attempt to tell you about the opportunities for CAs in IPR. And for that, I wish this session should be interactive one. Rather, I will be happier to answer your queries on the topic. I sincerely hope that the participants would find it useful. Okay, is my slides showing?
Yes, it's showing.
Okay, ma'am. Okay, our topic is professional opportunities for CA. Of course, these are some of the services which I'm showing here in my slide, uh, which are directly associated with the CA services, where their client asks for the IP services. CAs are the must needed professional for all these services. There are other than these services that we will discuss in later on slides. Okay. So then first of all, I would like to tell you about what is intellectual property and what is intellectual property right, how it came into the world and how it works in our day-to-day life. Okay, then intellectual property, legal right. These are the laws. These are the rights permitted by the law. Who are the creators of IP? Who are the owners of IP? They own this right. If if person is not owning that right, not owning the intellectual property, they don't have that right. That means if only the owner have that exclusive right. If other than the owner, use it without permission, they are infringing their right. They usually give a creator an exclusive right over the use of his or her creation for a certain period of time. Of course, all the IPs, whether it is trademark or copyright or patent, they are uh, grant for the certain period of time. Some of the IPs are valid for perpetually, and some have a limited span of time. Okay, then it is an intangible asset which can be sold, gifted, assigned, and licensed like any other property. Then there are the major laws governing IPR. I have only added five IP here, and there are so many other IPs are there, which maybe we will discuss on our later slide. But I have added only patent, trademark, copyright, GI, and design here. Okay, and now we have a small phone of Nokia. I should have used iPhone there, but this is my old slide. Then I am using the own Nokia there, and you may see a small phone of Nokia own different IP like trademark, copyright, patent, design, trade secret. Now, what is trademark here? The name of the phone, the Nokia, the word Nokia is registered as a trademark here. Then again, copyright, the whatever software they are using, whatever manuals they are using, ringtone, startup tone, images, the icons, small, they are registered in a copyright act as a copyright. And then we have patents. Uh, all the system, data processing method, and operational system, they are patented as, as per Patent Act. And the overall design, the outlook of that phone is registered under the Design Act. And there are the trade secret. Uh, mm, if I say trade secret, there is no law in India for the trade secret. Uh, this is for the technical know-how. And once the employee signed the contract with the company, they are bind by this trade secret law, which depends on the company to company. There is no statute or legislation which are owning this trade secret. Okay, first of all, yeah, we will discuss about the industrial design. Then design, what is design? Design is the outer look, it's the aesthetic of any product which is new and original. If you say, if your client came to you and they come for the final product, uh, and they ask you, uh, can I get the patent of this outlook, this design? Maybe it can be a bottle, it can be a shoe, or it can be a spectacle design, or it can be a chair, it can be a scooter, it can be a car. Okay, then what is the look of this product? It can be registered under the Design Act. But the problem is, if your client is already is using this design in market, there is a sale purchase has been started of the design, and before, yeah, the client came up to you, they go to the market and started the sale purchase of the same product, then it cannot be registered under the Design Act. So for design registration, we have to fulfill this thing. The design should be new and not published in the market, this is the condition for the design. Okay, and first of all, we know two, three things about the design registration. Uh, for every design, the inside arrangement of box cannot be registered in the design. For example, if your client came to you and say, uh, see, there is a cabinet under the almirah, there are the arrangement in boxes. Okay, there are some like money purse, there is a segment, there is a arrangement, but for that thing we have to open that product. Okay, we cannot get the registration of design, because design can be registered only for the like closed article, not for the open ended article. Okay, uh, then I'm showing you the that classical Vespa scooter is there, which is registered under the design act because of its aesthetic, or because of its unique design. Okay, now here you are showing, I'm showing you this design, which is not mentioned, where no trademark is mentioned, nothing, uh, nothing is written, but we obviously know what is this. This is a Coke bottle. Okay, how can we analyze this is a Coke bottle? This is a Coke bottle because we seeing this design from the beginning of the era, and mm, uh, this is very obvious design of Coca-Cola, and we can see without, we can analyze this thing that this is the Coca-Cola bottle without even that bottle does not have any label on it. That bottle can be registered as a design product. Okay. Then the Apple has very different and worldwide famous design as an iPhone. It is capable to distinct its product than other. We all have iPhone with us, and you can see IP Apple phone is different phone, different with that Samsung phone. Samsung is different from the other phones. The unique design can be registered as a under the design registration. Okay, then we have patent. Again, patent is an exclusive right granted for an invention. Again, uh, what is a patentable thing? Once client come to us, they call trademark as a patent, they call copyright as a patent, they call design as a patent. They come to us, I want to register my logo as a patent. They came us everything for the patent, but we need to analyze that what is that particular IP and for what purpose, and for what IP we can take it, uh, we can grant from the government. If it is it a logo, or it is a book, or it is an invention. If it is an invention, then it should be useful for general public. For patent, it should be uh, it should be useful, it should increase the quality of the human being, it should be, it should increase, invention should increase the quality of human being. And how can we analyze this invention is patentable or not? That should not be obvious. This should have the invention. If you have made the invention, it can be patented. To get the patent, technical information about the invention must be disclosed to the public in patent application. If this is uh, that we have discussed earlier about the design. uh, I already told you, for design registration we should have the uh, registration first and use it later on. And for patent, of course, we have to file the application first and use it later on. There is a mandatory uh, thing. If you have used it first and file it later, then it will not be granted to the applicant. Of course, patent is a monopoly right and it is valid for 20 years. Once you get the patent registered, it will be valid for 20 years from the date of filing application. And for this thing also, we have to renew it after getting the registration of patent. We have to keep it in mind. We have to renew it every year once it is granted to us. Okay. Then for patent, we have to apply in each country where we wish to claim our invention. The invention has to be made public after the filing of patent application. Patent right. The patent owner has the right to decide who may or may not use the patented invention for the period in which the invention is protected. Of course, patent holder can give you the license, or it's his or her wish that he want to exploit it uh, solely, or he may grant you a license or may not. In other words, patent protection means that the invention cannot be commercially made, used, distributed, imported, or sold by other without the permission of patent holder. Once the patent expires, the protection ends and the invention enters the in the public domain. Then anyone and everyone can exploit it, everyone can use it. Then what came out of it? That patent, once it is granted, it is valid for 20 years only. After 20 years, anybody can use it and everybody can use it. Okay. Trade secret. What is trade secret? You have we have all we all drink the Coca-Cola, and we all drink thumbs up, and there is a slight uh, difference in the taste. Okay. The When we drink uh, cold drink, we see that one cold drink has a different taste and another is a different taste, and we can analyze after drinking whether it is Pepsi or Coca-Cola or thumbs up. Even if they all are in black color, we can analyze, right? But what makes that taste different? That is a confidential and secret business information, and that is protected under trade secret. But there is no law in India. Once it kept in the paper and it is closed between some of the employees or managerial person in the industry or a company, and if it is disclosed, you can make the you can sue on him, or there is no other way to deal with it. Okay, next is GI. Of course, GI is the sign and which can be used by the geographical specific geographical origin and possess qualities and reputation. We all had Rasgulla, Bengali Rasgulla. Of course, we we say it Bengali Rasgulla because it's a GI tag on it that says it's a Bengali Rasgulla. There are many other GIs, just like Darjeeling tea or Mysore silk or Kullu shawl. Uh, who can apply for geographical indication? Who can apply for the GI? Any association of person or producer or any organization or authority who belong to that particular geographical area, they can apply for the GI. Okay, now we have copyright. Again, it is an exclusive legal right to reproduce an original work of authorship fixed in any tangible medium of expression. In case of dramatic, music, geography, choreography, film, advertisement, sculptural work, computer program, databases, technical drawing, and math. Once we get the copyright done, we can prevent our copyright work from the infringement. Different cases of copyright work, different classes are there. There are the literary and dramatic work, where books came, and dramatic work, or like जो भी आपने books create किया है, that come. Artistic work, the paintings, the artwork you have done, cinematography, film, all the movies and serials and advertisement, they come into that cinematography work. Next is sound recording work, that all sounds uh, used in the movie and shows, that all came into under copyright. Music work, all the music, all even notations, uh, background music, all cover under that music work, and that will be registered as a copyright. Then again, computer software work. In India, computer software work registered under Copyright Act. In US, computer software work can be registered as a patent. Okay, this is the website which Copyright Office has, where you can here file the application. These are the statutory fees of copyright. If you are filing a literary work, that means if your client wrote a book and they come to you and they want it registered as a copyright, then government fees is only 500 rupees for non-commercial use, and if they commercially exploit it, they need to pay 2000 rupees. And again, dramatic work, for dramatic work the government fees is 500, and even if they are commercially used, the government fees is 500. The fees and the charges are very, very nominal. For artistic work, for example, when your client came to you and they say, I have designed a logo, or I have designed a I have just done my painting done, then the government fees, you can pay the government fees and you can register your artwork. Again, for movie production and movie registration and copyright, you can pay 5000 fees and get it registered. And the list is there available on the site, where you can see the fees and file your application. What is not copyrighted? Of course, the rights which are covered under trademark, just like names, phrases, and symbols, which are registered, which will be registered in a trademark, as a trademark, that cannot be registered as a copyright. Okay, then copyright can be registered for a tangible form of expression. If something is running in your mind and you cannot express it in a tangible form, in the piece of paper you cannot get it, then it cannot be registered as a copyright because it is in your mind. But for registration, you need to uh, we have to submit it in physical form. Okay, then traditional ideas, procedures, methods, they cannot be registered as a copyright. Okay, then work consisting entirely of information which is a common property, weight chart, height charts, tape measure, that cannot be registered. Even if you are making a small modification, you can, your client came to you and they are saying, I have made a different kind of calendar. But calendar is calendar. If you have made a change in a, if you have made something valuable, okay, then only it can be registered as a copyright, otherwise not. The next is trademark. Okay, trademark is it means a mark capable of being represented graphically. It can be used for goods and services. These are some of the examples. Our ICI logo, ICSI logo, Adidas, Adibon, and Nestle, they are registered as a trademark. Some of my colleagues and some of my friends, they are confused with the device mark or logo mark and label mark. There is no need to having problem in it. They all are same. If we are if there is no logo, you are just texting a word, then it's a word mark. And if there is a device, there is a artwork behind the logo, there is a design and uh, specific logo is there, you can get as a device registration. And if it is label, label means any wrapper which is like Bisleri label on the Bisleri bottle, that can be registered as a label. Okay, and we can registered in their them in a combination. We can we can get the registration on it. Just like I have made a slide. If you are filing as a Google as a word mark, just typing the text, it can be registered as a word mark. You can take a number for filing a trademark. 555 is the brand, and you can use numbers as a trademark. There is a device. It's a Amul girl is there, and this is when we are using this kind of uh, images behind our logo, behind our trademark, you can use it as a device mark. Again, packaging, packaging or label, this is one of the same thing. There is dairy milk label or a packaging. You can uh, use it as a whole for a trademark registration, where Cadbury is mentioned, dairy milk is mentioned, and from the upper side milk is pouring on the chocolate. So this is the complete packaging, and you can get the registration of the complete package. This is called the label. Again, the product mark and the service mark. If the logo is design is presented on the product, it is the product mark, and if uh, it is available on the service, then it is a service mark. Shape. Okay, then um, ab- abhi, later on we have discussed about the design registration. Design registration and the shape registration are the two different things. Whatever is the shape of your goods, it can be registered as a trademark shape, but the product itself, it can be registered in the design act. We can register the pattern also, so that we cannot face any infringement. Okay, then there are the collective mark, just like ICSI, ICI, they are the collective mark. As the name suggests, these marks link with the group of people. This is not associated with the single person. The person who are the part of these organizations can use it. The members mm, can use it, this word CS or ICSI. Okay, then the certification mark, I, ISI, agro, these are some certification mark which can be used by the person if their product and services are meet the standard, some standard, then you can use these certification mark. Again, sound mark is there, just like you have heard the sound of Britannia, ting ting ting. That is a sound mark, and that is registered under the trademark. And color combination, you can use the color combination. What is the purpose of that color combination? Because just like Coca-Cola, they have red color background, and uh, uh, they have used on a white bottle Coca-Cola. Okay, that nobody can use it. If Pepsi wants, they can use this combination. No, they cannot use it. If they use it, uh, in spite of they are using Pepsi, in spite of they are writing Pepsi on the same color combination, they cannot use it. If they use it, it will be the infringement. A trademark can be designed by the following symbol. A trademark can be designated by the following symbols. TM. When we write TM over our trademark, then it shows that your trademark is applied, but it is not registered till now, and that is under process with the trademark department. Okay. Then if you are using R in circle, then it shows that your trademark is registered and valid, and you can use it. And if anybody use this mark, you can file infringement suit against him. What are non-registrable trademark? Of course, mark resembling existing and established mark. If you chose a mark which is already existing, which already established, then this is not a registrable mark, because it is owned by someone. Confusing or deceptive mark. If you chose a confusing mark, like uh, Coca-Cola, if you are using the color combination of Coca-Cola, and you are using you are mentioning K instead of C, then again it's a confusing mark. You are not allowed to use this mark. Descriptive mark, such as coffee shop or coffee bar, descriptive mark, they are directly associated with the services and products you are providing. These are the descriptive mark. And coffee shop for a coffee, these are not allowed as a trademark. Tea shop for a tea, no, that is not allowed as a trademark. Unlawful mark and prohibited mark, of course there is a list of prohibited mark that is available on the government site. A scandalous and religiously inflammatory mark, these are also not allowed. Again, laudatory and superlative words, just like best, perfect, premium, plus, gold, these are not allowed. Of course, anybody and everybody can say their mark as a best, perfect, supreme, super, plus, they can use it. But yes, of course, if your mark is already registered, then you can if you want to show the variants of your product, then you can use. If you are selling a small if you're selling a pen with the name of Rotomac, and you are using premium Rotomac and Rotomac and gold Rotomac, that is allowed, but you cannot use word only premium and plus as a trademark. Next, well-known trademarks. Of course, well-known trademarks are those which are uh, just like Apple. Apple is a well-known mark, and well-known mark get the special recognition. They get the special advantage from the other trademarks. Because if you are using Apple for gadgets and electronic items, you cannot use Apple for garments. You cannot uh, mm, take a trademark for the chairs. You cannot manufacture tube lights with the name of Apple. Clients come to me and they ask, ma'am, Apple is not providing any light. They are not manufacturing any chair. They are not into furniture. Then we can use the word Apple? No. These are the protection allowed to the well-known trademark if they are not registered in particular goods or services, even though we cannot use them in particular class. Major benefits of well-known trademark. Well-known trademark are better recognized than a registered trademark. If you have a registered trademark, you can stop someone from using that particular trademark for the particular class. For example, Biba. Biba is a registered trademark. Uh, they are for the um particular product. They are into garments, like, okay, but they are not well known. If they want to get it as a well-known trademark, they have to file an application, and the filing fees for the well-known trademark is 1 lakh rupees. If you want your and you have to uh, like satisfy the registrar that your trademark qualifies as a well-known trademark. These are the some examples: Bata, Bisleri, Whirlpool, Honda, Infosys, KitKat, Philips, Pizza Hut. These are some of the examples which are registered as a well-known name, and we cannot use it for any other services for which they are not using it. Okay, advantage of trademark. Prior applicant to trademark registry is the owner in most of the cases. Of course, if you come, uh, f- if there is a trademark ABC, okay, and you came to the trademark registry, and if it is clear, if it is not registered with anybody else, you can get the registration. Okay, and of course, in many of the cases, this formula applies. We will discuss later what is the problem in it. It gives statutory protection for 10 years at a very minimal cost. We have discussed about patented design, and where I have told you that we have to uh, file it first and then use it. But in case of copyright and in case of trademark, there is no such kind of objections. If you are using it first and file it later, it can be, it cannot make it, it is not any problem. Okay, then it gives legal protection against infringement. If you are a registered trademark holder, you can go to the court, you can go to the registry that my trademark is registered, and they will file, they will grant you the injunction against nobody can use it. Trademark registration in other countries worldwide on the basis of Indian trademark registration. Of course, if your trademark is registered in India and if you file trademark in abroad, okay, you can get the registration very easily. Some of the countries, just like Nepal and Bhutan, they consider your our Indian registration, and if you are registered here, they grant us in their country very easily. Registered brand can use R, and unregistered brand use TM in superscript manner. Of course, that we have discussed already. It works as a brand advocate for new and existing customers. Brand advocacy is if your trademark is registered, everyone and anyone can know you very well. Okay, that we have discussed later that prior applicant is a prior registration holder. There is a some problem in it if there is a priority in adoption prevails over priority in registration. Although registration of trademark is prima facie evidence of the validity of trademark, yet the registration cannot upstage a prior consistent user of trademark. That I'll discuss that if your parents and grandparents, if your client using this any of the trademarks for 50 years and they don't know about the registration of trademark, you can get the registration right now. And if anybody already using this name, you can stop them, you can stop them from using it, and you can go for the cancellation of their trademark. That's why priority in adoption prevails over priority in registration. Sorry, I think there is an interruption. Okay. Okay. In India, we can have civil action or criminal action. In case of registered trademark, passing of an infringement, we can use. Okay, then what happened? One minute, ma'am. Okay. I think there are no participants, right?
can see four participants on my screen.
Okay.
Yeah.
But these are not visible to me, ma'am.
Yeah, even I don't see them.
Okay. They are the participants.
I think
Okay. Let it be. Isn't Indian trademark valid abroad? Of course, no. Indian trademark is not valid abroad. If trademark you have registered your trademark in India, it is valid in Indian territory only. And if you wish your trademark should be valid in abroad, you have to get the registration in that particular country. Certain countries, however, do recognize Indian registration as a basis of registering the mark in those countries. Just like I have told you, Nepal and Bhutan, they recognize their registration, but in other countries, they have the full-fledged prosecution. They of course, if they will send you the examination reports and all, if some similar mark is existing. Okay. Then does registration cover other countries? An Indian trademark registration only covers India. It does not, therefore, afford protection in any any of other country. Separate application must be filed in each of these countries if registered protection is required. Okay, then if your client is in India and they have registered their trademark in India and they wish to export their goods, they wish to expand their services in a particular country, you can hire attorney there, or you can file trademark in that particular country. Of course, we have to hire their advocates in their country for getting the registration done. And there is a WIPO application also. Here you can register, you can apply for a particular countries where you want to get the registration. There are some 120 countries are there in the WIPO. There you can tick the particular country in which you want the registration, and single application, and by single application you can get the registration and you can apply for the trademark in all those countries with the single application. But there is a problem in this application, because if you have filed WIPO application and tick you, you tick for 5 countries. Let's say, let's take one example. You take 5 countries for you want the registration, and 4 countries grant you the registration, and one particular country create objection, then it will not be registered. Once the all the objections the objecting country creates, and you fulfill all the requirements of that country, then usse pehle it will be not registered in your name. So there is a problem in this WIPO application is there. And if you go to a particular country, you can get the registration. And of course, convention priority can be claimed if you file application in India. Let's say on 1st of January 2024, you filed an application in India, and within 6 months, you are filing application in abroad, then use you can claim the user of same that you used in India. Okay, duration of intellectual properties. Of course, trademark. Uh, I think uh, it's some old slide. Trademark is valid for 10 years and renewable after 10 years, and that is valid for the infinity. Like, if if today you filed a trademark, and then it will be valid till 2034. Okay, and before expiring date, if you get the renewal done, then again it will be registered for next 10 years. Okay, and that's is going on. And in case of copyright, copyright is valid for the entire life of the author and 60 years after the death of the owner. Next, patent. Patent is valid for 20 years once it is granted, and if it is granted, you have to renew it every year. If you don't renew it and it is expired, it will come into the public domain, and anyone can use your invention. So this is very important thing. If you have applied a trademark or a patent or a copyright or any IP of your trademark of your client, then client and we as a professional should keep it in mind that renewal is very very much mandatory. If your client is working, your client is using that IP, it is very very important. Again, design is valid for 10 years, and that can be renewed for the period of 5 years, and that is maximum. So design is totally valid for 15 years, 10 plus 5 subject to renewal. Patent is valid for 20 years subject to yearly renewal. Next, copyright, there is no need to renew it. It is valid till the life of the author or a owner, and after the death, from the day of death, it will be valid for 60 years. Then royalty can be used by their legal heirs. And in case of trademark and GI, you can these are perpetual, and these are valid for 10 years, 10 years, 10 years, 10 years, and so on. Next is trademark search. This is the trademark site where we can search our trademark before filing. Uh, mm, I think my CS friend, which are create company or incorporate the company, they are well aware of this page, and they know how to search the trademark, how to search name of the company. This is the site, and this is the jurisdiction of trademark registry. There are the five jurisdiction, but nowadays when we file trademark online, we file copyright online, there is no need to specify the jurisdiction. But again, there are I have mentioned it. This is there the Mumbai, Ahmedabad, Kolkata, New Delhi, Chennai. Once upon a time, we visited there for the hearing purposes, opposition's hearing and show cause hearing. But nowadays, everything is virtual, so we are not going there for the hearings. Once upon a time, these offices were very very important for us. Again, this is the fee structure. TMA, that is the application for registration. The government fees is 9,000. In case of you are a body or incorporate, you are a body corporate, or you are a partnership firm, or you are a trust, or you are society. For everything, you have to pay 9,000. But if you have MSME registration, and if you have startup registration with you, your government fees will be just half, and your government fees will be 4,500. And in case of individual owner, the government fees is already 4,500. Then again, TMM. Form is just for the amendments purposes. If your client says they have changed their address, you can file TMM. You can like make the amendment on it. For TMR is for renewal. Once uh, your renewal is approaching, your ninth year of registration is approaching, you can file TMR is in advance before it expire. Okay, and this will be valid from the date when it will be expired. TMC, again, when you file copyright application for a artistic work, right? Like packaging, like any box, like dairy milk box, or it's a packaging of a bigger. It's an artistic work where you have mentioned words, and you have mentioned art. So in that case, you have to take a NOC from the trademark department that no right of any trademark holder are infringing. Then there is a TMO. If you want to oppose anyone, if you file the opposition, trademark opposition, then you can use TMO there, and the fees is 2,700. And for both filing notice and for the counter statement, for both the purposes, we have to file TMO. Then TMP, if your IP, your trademark is you are not using it, it is an idle form, you are not pursuing your business, then you can assign it to somebody. You can sell it off to somebody. Then TMP, of course, For the subsequent user, so the second user, the second owner will file a TMP with the trademark department to show that he is now the current owner of the trademark. Then for license purposes, there are the TMU and TMG for the trademark agents. And this is the flow chart of registration of a trademark. We have to conduct a search first of all and file a trademark. Then a trademark department examine your trademark. Is it new or unique or not? If it is not unique, if it is similar or identical or not registrable, then they create objection. And if it is good to go for a trademark, then they will accept it. And once you get the objection, you have to file a reply. You have to annex your evidences that you are using it and you are not getting any problem from the outer world. And if the examiner, the learned officers are satisfied with your reply, this is again the opportunity for the CAs to draft these replies and file with the trademark department. Again, hearing come if they are not satisfied with your reply. If hearing come, we can appear for the virtual hearing. Nowadays, there are only virtual hearings, show cause hearings, and if it then if registrars are satisfied, they publish it in a their journal. And if these are if within a 4 month time you are not getting any opposition, of course it will be registered perpetually perpetually subject to renewal. And first of all, it will be registered for 10 years as a registered trademark. And if it is opposition, you get the opposition on TMO form, then you make a reply within 2 months. And if it is 2 months, one day, your client will gone. Your trademark is just gone. You are vanished. You have to, they will not take you the like the extension of a one day. So keep it in mind. If your client uh, if your client get the opposition notice, the time for filing the reply is only 2 months. And after reply, they uh, there is a further process. They have to file their evidences, opponent file evidences, and applicant file their evidences, and they call you for opposition hearing. Again, the role of IPR in business growth. Of course, there is a um, vital role of every IP, whether it is trademark, copyright, patent. Um, if your IP is registered, obviously it encourage investment and funding. If your IP is registered, your clients, stakeholders have trust on you because it's risk free investment. They may uh, fund your business. There is no problem in it. Monetizing and licensing. If you want, uh, you can create revenue by licensing your intellectual property. You can monetize it. International expansion. If you have strong IP protection, allows business to expand into global market without with reduced risk of their innovations being copied. increased revenue through IP asset. Companies with strong IP portfolio often generate significant revenues from licensing deals, boost in market value. Business with strong IP protection typically have higher market valuation. Study shows that the business with well IP, well protected IP are more attractive to investors, which can result in higher stock prices. Competitive edge advancement and advantage. Firm with patent enjoy monopoly right up to 20 years, enabling them to control market share in their industries. Okay, there is IP prosecution with IP authority, pre-grant, post-grant, and uh, pre-grant and post-grant. So if your IP is registered, uh, your rights are different. If your IP is not registered, your rights are different. In pre-grant, in pre-grant, there are examinations, there are show cause hearings. Um, you can your client come to you and say they have received objection. You can prepare a reply of it. You can, if you can appear for the hearing also on behalf of applicant, not as a trademark attorney. And again, if your client is in market uh, since uh, since long, and you are into a pre-grant period, that means your trademark, your patent is not registered. You can, if anybody is using and passing off your trademark or using your copyright and patent, you can sue them, and you can go to the court and you can send a legal notice. Of course, if your trademark and I or your IP are registered, that means they are into post grant period. You can go to the court for the infringement, and they will pass court will pass the uh, um, uh, injunction order. They can give you a stay order in your favor. If your trademark is registered, then nobody can use it. Here are some examples of smart infringement and passing of trademark. In first go, they all are Bisleri, that we drink uh, water from it, and it's quite hard to analyze which Bisleri is right, because when we are on the highway and we want to drink water and we are feeling thirst, then if we take bottle from the on the highway and drink water, and it's green label bottle we take on highway and we drink water, we cannot analyze is it Bisleri or not, because on a first go they all are Bisleri. And after emphasizing on it, you can get to know, oh, the C1 is the right Bisleri. Okay, so these are the smart infringement and passing off, and you can go to the court because Bisleri is a registered trademark, and they can go to the court directly, and they can get the stay order against the infringer. Again, this is the Amul milk, and there is a trademark infringement and passing off, and you can see the whole entire packaging. They have copied. Matlab like if we as a like uh, smart people, educated people cannot identify in a bit of second, we cannot analyze. How can we uh, for uneducated people, what can we say? Okay, then trademark infringement, it must be registered and eligible for legal protection. If you go to the court for the trademark infringement, first of all, keep it in mind that your trademark should be registered and valid. If it was registered 10 years ago and you have not filed the renewal, you have not paid the renewal fees, then you cannot go to the court for trademark infringement. Then you have to go to the normal court for the passing of thing. Injunction cannot be granted quickly in that case. But in case of infringement, uh, court listen to us, and within we go to the court, and we take the stay order within a 1 day from the court. The person who claimed that infringement has happened must own the mark, who should be the owner. Uh, Recently, we have a case uh, where the owner was expired recently, and their uh, their dealers have started using their trademark, and the widow of the owner has filed the infringement case, and the defendants raised the objection that she is not the owner. But by luck, we have already started the process of assignment, transmission of trademark, because the owner was expired, and in that case, transmission of trademark uh, application we pursued with the trademark office, and they have accepted it, and a court has accepted it, that the widow of the owner is a new owner, and the legal heirs will be the owner. And of course, that shows that the trademark owner should own this trademark. Okay, then unauthorized use of the mark must be connected. That means if you have given the license to the party, another party, you cannot say it's unauthorized use. If you have assigned your trademark to someone else, you cannot say it's an unauthorized use because you have signed the document. Remedies available to the trademark protection, civil remedies. These are the civil remedies, and both civil remedies and criminal remedies are simultaneously available against the infringement and passing off. Where you can get the injunction order, court give you the injunction order in your favor, and restrain defendant from use your trademark. Y- uh, then damages, you can get the damages, you can compensate for the loss. If defendant has used your trademark for the 6 months, they will pay you the damages, and accounts of profit, you can get the whatever the profit they have made, again the damages, and surrender of infringed damage, and surrender of infringed goods. Whatever goods you have infringed, of course uh, you can get them. They have to surrender, defendant had to surrender their trademark, cease and desist from using infringed mark, and court cease and desist defendants from use your trademark. Again, remedies, against infringement, that I have already told you. Okay, then qualification of a trademark agent. If you are a mm, if you want to file a trademark, you work as a trademark agent. Either you should be first of all, you should be the citizen of India and 21 of age, graduate. Then you have to file a examination that will be conducted by the trademark office time to time basis. And if you are an advocate, you are you can be a trademark agent or trademark attorney. And if you are a member of ICSI, you can be work as a trademark attorney or a trademark agent. Precautionary moves. Once your IP is protected, once your IP is registered, obviously the work is not end up here. We have to watch them day to day basis on we have to protect them, and we have to make an internet such that is anybody using your IP or not, and consult your counsel for any ambiguity, any registration may you have made. uh, you can consult your counsel for any problem. Now, thank you. This is from my side, and I'm open for the queries if anyone have.
Yes, ma'am. There were some questions regarding what are the opportunities for chartered accountants, like for fresh chartered accountants, and how a chartered accountant can benefit from these laws.
Yes, ma'am. Of course, they can work as a mm, IP valuer. They can work as a for IP audits. Okay, and of course, when client come to you, okay, you can file. Of course, you cannot use your DSC because CAs are not allowed as a because they are into their practice, they are not allowed to use their DSC for the filing purposes. But of course, they can use the client DSC, they can file the trademark, they can work on client's behalf. Okay, and of course, in merger and amalgamations and in takeovers, IP valuers are there, and without chartered accountants, I don't think any team in any merger and amalgamation or any takeover can be done without a chartered accountant.
So, what would be like qualification for IP valuer, like
There is
the
there is no qualification. If you are a chartered accountant, that's enough. And you are if you are a part of a team in merger amalgamation, and you can do the IP valuation. IP audits are there. Uh, that was my first slide.
Yes, yes. Okay, thank you so much, ma'am. And it was a wonderful, great learning session, very elaborative, and surely we can know the difference between the patents, copyrights, designs, and GIs. We assume that there is the names are different, but we assume that they are same, but no, they are different. And the process, the how do we register those patents and copyrights? It was very elaborative session. Thank you for your great talks. And on behalf of the committee, I thank you all the participants for attending this webinar. Thank you so much, ma'am. Can I close the session?